We got breaking news out of the Washington Supreme Court. The oral argument between the state of Washington and Gators Custom Guns out there in the Washington Supreme Court occurred earlier this week. We have to cover it, hit some of the highlights, and we'll talk probably more about these magazine bans in the future. But for now, let's talk about the argument before the Washington Supreme Court in terms of the state's ban on magazines that hold more than 10 rounds. Stay tuned. Hey folks, I'm Mark Smith, host of the 4 Box of Downer, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a finalist, top 5 finalist in the category of top voices of the Second Amendment for the 2025 Gun News Awards. Only a few more days to find out whether or not we've won, and I appreciate all your support for getting me this far. I'll let you know what happens in just a couple days. Very exciting. Looking forward to getting out to Las Vegas and talking to other members in the Second Amendment community. Always a fun time. All right, folks, so I'm a few days late on this, but better late than never. I'm sure Washington Gun Law and William Kirk has already covered the 6 ways to Sunday, but I want to add my 2 cents in on the Washington Supreme Court's argument in Washington versus Gators Custom Guns. This is the case involving the state of Washington's 2.5-year-old ban on magazines that hold more than 10 rounds. Now, this should be an easy case if you simply apply the United States Supreme Court decision in Heller. But of course, when you're in front of these kind of like liberal anti-gun jurisdictional judges, like we expect to see in the Washington Supreme Court, maybe we'll be happily surprised. Maybe they will follow the law. I can only hope and pray. That's what should occur. But, I'm not holding out a lot of hope because I've seen what goes on in places like Oregon, Washington State, New York, New Jersey with a lot of these courts. And again, they're in blue state jurisdictions with people that are picking judges who tend to be blue state type folks. So you kind of get that kind of judge. But, let's see what happens. But in the meantime, let me analyze some of the arguments that were raised both by the state of Washington and also by the lawyers for Gator Custom Guns and analyze this under the Second Amendment. To begin with, the first question, of course, is you have the text of the Second Amendment, which is the right of the people to keep and bear arms. So the first question is a magazine an arm? Well, the answer is undeniably yes, and there's a bunch of different ways to get to that answer. The first way, of course, is to simply say it doesn't actually matter if a magazine in and of itself is an arm under the text of the Second Amendment, because a ban on a magazine capacity limit is, guess what? It's an actual ban on a semi-automatic modern firearm. And what do I mean by this? We've covered this before. If you ban magazines that hold more than 10 rounds, let's say, what have you done? The state of Washington has banned, right, an entire category of firearms that are capable of firing more than 10 rounds without having to be manually reloaded. So whether or not you want to argue that magazines are arms in of themselves, the reality is a magazine ban or a magazine capacity limitation law is a ban on an entire category of firearms that are in common use by Americans for lawful purposes, and therefore it's unconstitutional under the Supreme Court precedent of Heller that said that handguns, because they're commonly owned by Americans for lawful purposes, cannot be banned. Can't ban an entire category of firearms that are in common use by Americans for lawful purposes. And firearms in the United States that fire more than 10 rounds are obviously ubiquitous. They're all over the country. And remember, this is a national standard. It doesn't matter what's the story in a particular jurisdiction. It's a national standard because the Second Amendment is a national law. It's the federal Constitution. So that's the first thing, that a magazine ban is a ban on a category of firearms in and of itself. But beyond that, what's going on here is that the anti-gun movement tries to say, well, magazines in and of themselves are not arms. But of course, and this was alluded to by a judge in this oral argument, well, so that could also be the case with a barrel or a trigger or a bore or a sight, right? These are things that you need to make the gun go bang. And again, a magazine is something that holds the ammunition in the gun, and thus it's a necessary component of a gun, because otherwise, how else can you hold How else can you hold ammunition in the gun without a magazine? So obviously it's a necessary component of a gun because you got to be able to hold the ammo in some way into the gun. But beyond that, the question as to whether or not a magazine is a required or necessary component of a firearm is utterly irrelevant anyway, even though it arguably is, because of what the Supreme Court specifically said in the decision of Nysurpa versus Bruin about modern firearms and modern instruments that facilitate self-defense. Let me remind you what the Supreme Court itself said in 2022 in the Bruin case about instruments, not weapons, not arms, but instruments that facilitate self-defense. Here's what the court wrote. Thus, even though the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition covers, listen carefully folks, that general definition of arms covers modern instruments that facilitate armed self-defense. You see the word? It doesn't say requires or is essential. It just says it facilitates, which means it helps. And obviously magazines of any capacity facilitate or help with self-defense. That's why police officers and other people carry these guns, because they facilitate self-defense. So they don't even need to be required, even though they obviously are, because holding on to more than one round requires a magazine, and modern arms are protected arms. So unless you want to go back to single-shot revolvers, or I should say single-shot pistols is what I meant to say, well, guess what? You're going to have to hold on to multiple rounds in a gun under modern law, under modern technology, and that's going to require some form of a magazine, which means obviously it's necessary and thus an arm. But let's go beyond that. So the state of Washington, again, screws up the methodology of the perspective of how one assesses constitutional rights. Here is what the lawyer argued on behalf of the state of Washington. He argued nothing in Washington's Constitution or the Second Amendment requires states to allow the sale of firearm accessories that have virtually no utility for self-defense and instead are routinely used in mass shootings. So there's two major problems with that argument about magazines. First of all, when you assess and evaluate constitutional rights, you only look to how law-abiding Americans lawfully use these. So for example, you don't say because somebody might use their right to free speech to defame someone, to commit fraud, to lie, to cheat, to engage in fighting words, whatever, or engage in obscenity, whatever you want to say. Just because some people may misuse their oral, their verbal, their written communications, their free speech, has no bearing on limiting the right of others to speak freely. And this is specifically the case when it comes to the Second Amendment, because if you look, for example, at the Heller decision, the entire decision by the majority, written by Justice Antonin Scalia in Heller, laser focuses on how people lawfully use handguns. But then if you look at the dissent by Justice Stephen Breyer, he's talking about how handguns are misused by criminals. But again, it was irrelevant that people misuse handguns because you don't measure or limit the right to keep and bear arms by virtue of how people misuse them. So an argument by Washington State saying that, hey, mass shooters use rifles, which is kind of not really true. They actually prefer handguns, but set that issue aside. But arguing that they prefer these kinds of magazines and rifles or whatever, well, guess what? It doesn't matter for the purposes of delimiting or identifying or articulating and setting forth the scope of the Second Amendment right. It's totally irrelevant how it is misused. That is basic black letter constitutional law. But beyond that, if you look at what the argument is, it's really a form of interest balancing, because he's saying here that on the one hand, these magazines have virtually no benefit for self-defense. There's no utility for self-defense. On the other hand, they're helpful for criminals doing criminal things. But what does that speak to? You know what that speaks to? If I start saying, well, look, it doesn't really have a lot of value to Americans, but it has a lot of value to criminals, Well, that sounds like you're engaging in what? Interest balancing, which the Supreme Court has repeatedly said in the Second Amendment context. There's no interest balancing between the good and the bad of firearms, and that it was exactly what the argument was being made by Washington State, which is verboten in Second Amendment jurisprudence. The next thing we saw during the argument was their long kind of discussion about a historical tradition of regulating particularly dangerous weapons. Now let's hold on for a moment. The Supreme Court in Heller literally already did the text analysis and already did the historical analog research and analysis to identify under what circumstances is there a historical tradition of banning arms. And the only historical tradition in American life at the time of the founding and earlier that could possibly be used to justify the banning of arms is if the arms are both dangerous and unusual. They have to be both. And because, and listen carefully, this is a very nuanced point, so a lot of people miss what I'm about to say, so listen carefully. And because that dangerous and unusual standard, the historical tradition of being able to ban the carrying of dangerous and unusual weapons, arose in the context of the historical portion of the text first, burden shifting to the government, historical tradition analysis second. The burden is on the government to show that an arm is dangerous and unusual. Hear what I just said? The burden is on, in this case, Washington State to show that these magazines that hold more than 10 rounds are both dangerous and unusual. And it is simply, in my view, impossible for the state of Washington to show that these ubiquitous magazines that hold more than 10 rounds, I mean, every semi-automatic handgun of 9mm or bigger, right, set aside maybe some 45s, will have magazines that hold more than 10 rounds, and certainly every AR style, AK-47 style rifle is going to have magazines that hold more than 10 rounds in the normal course. So it's impossible for the state of Washington to show that these magazines are not dangerous and are dangerous and unusual, because there's no way they can show that these are unusual because they're in common use by Americans all across this country. There's no dispute about that. And the burden is on Washington because, again, the dangerous and unusual test, which gives rise to the in common use test, because if something's in common use, it cannot be unusual. And if it cannot be unusual, it cannot be obviously dangerous and unusual. That occurs at the historical portion of the text first and history portion second, right? It occurs at the history part of this, which means the burden of proof is on the government to show and satisfy the historical basis of the historical portion of the test, and they're not able to do that. But again, even if something is particularly dangerous, that is not enough to ban it if it's already in common use. And by the way, as a side note, the Supreme Court already made clear that arguments about mass shootings are a no-go zone and don't count in the Heller case, because remember, Heller was decided in the year of our Lord 2008. And what happened in the year of our Lord 2007? We know what happened. The Virginia Tech shooting, where dozens of students at Virginia Tech University were killed by a crazy guy with handguns with magazines that held more than 10 rounds. So you had modern semi-automatic handguns with magazines that hold, quote-unquote, large capacity magazines, killed dozens of people in 2007. These arguments and this discussion about the Virginia Tech shooting was specifically brought up in the Heller case, and the Supreme Court rejected all of that in deciding that handguns, which is indeed the most common instrument used by mass killers, if you want to go down that path, but it's not relevant, but if you want to go down that path, that's true. Certainly more so than anything else. And if you want to talk about magazines, all of that was in the gestalt. It was in the soup, if you will, of the Heller decision. The Heller rejected all of that to come up with the in common use test to say that because handguns were ubiquitous and everyone owns one, basically, they're in common use, it can't be banned. Period, full stop. So too the same with these magazines. And again, the burden's on Washington State to show they're not in common use, and that's simply impossible because they clearly are. They're ubiquitous. Everyone has 1,000 of these things, basically, in American life, outside of the crazy jurisdictions that ban them because they're anti-gun. And trust me, if you didn't ban these magazines in these other jurisdictions like New York, New Jersey, California, you'd have probably double the number of these magazines that hold more than 10 rounds. And then just to wrap up a couple additional arguments here, there's a big debate here in this case about were there any historical analog laws? But first of all, it doesn't matter because the Supreme Court already looked to the historical analog laws to come up with a historical tradition dealing with arms ban cases in Heller. They already did the work. But what's gone on here is I warned people in one of my articles in the Harvard Journal of Law and Public Policy, I specifically warned that what's going on here is the anti-gunners hate the Heller result. So they're trying to pretend that Heller doesn't exist, and they feel like, or they're trying to argue that the 2022 decision in Bruin is the first time the Supreme Court ever set forth the text first, burden shifting to the government, history analysis second. They're trying to argue this is the first time this ever has been seen, but it's BS. Because all Bruin did is take the Heller methodology and make it more paint by numbers so the lower courts would be less likely to screw it up. But Heller and Bruin are the same methodology. The difference is that Heller dealt with an arms ban case and set forth the constitutional test for when an arms ban may be constitutional and when it's not constitutional. It already did the work. It looked at the text of the Second Amendment and analyzed it. It then looked at the historical analogs and then drew principles from that and then created the constitutional test governing arms ban cases. It did the work in 2008 in Heller. Don't let these anti-gunners pretend that Heller doesn't exist because it's exactly what they're trying to do because they're trying to get a second bite at the apple. And hopefully, of course, the U.S. Supreme Court is going to grant cert in Snope and or Ocean State Tactical and resolve this once and for all and get these lower courts to line up under Heller and stop misbehaving and screwing up because they're not doing it. They're pretending, in my opinion, that they don't understand Bruin. They don't understand Heller. It's so confusing. That's BS. They don't want to understand it. They don't want to rule in favor of the Second Amendment because they think you're a peon, a serf, and a subject. They don't want you to be a citizen. And that's why they're looking for their legalese to get around respecting the clear and unequivocal text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. That's awfully clear. And the Supreme Court jurisdiction corroborates that. But these lower courts don't like it. These lower courts in these blue jurisdictions with these blue state politicians don't like the outcome, and they're looking for ways to play dumb to get around it. And it's time for the U.S. Supreme Court to step up and fix it. But I don't control that. That's up to the Supreme Court, and I hope they do their job and show the fortitude and courage necessary to enforce the law of the land, to enforce the Constitution against these rogue courts. Now, with that said, will the Washington Supreme Court demonstrate itself to be a rogue court, ignorant, and ignore Supreme Court precedent, or to pretend it doesn't understand it? Well, the history of the future when it comes to the Washington Supreme Court has yet to be written, so we will see. I've got my fingers crossed, but I have to say I'm not overly optimistic because it's the Washington State Supreme Court, and we know a lot about Washington politics, which really is America controlled by Seattle. That's how I view it. You tell me if you disagree with my take on that, but that's how I view, again, the state of Washington. It's America controlled by a major urban city, capital city, Seattle, and they lord over the rest of the state. But again, you'll tell me if you disagree. All right, folks, well, there you have it. That's kind of my quick summary of the Washington State versus Gator Custom Guns case, at least the oral argument. I may do some more analysis of this if I have a little bit more time over the next week or two, play some clips for you. But for now, I think that will suffice to kind of get you up to speed as to where things are out there. And we're cheering for Gator's Custom Guns. I hope they win the case. So there you have it, folks. Make sure you follow me on X at @4boxofdiner. We have over 22,000 followers now. Make sure you subscribe to both my channel on Rumble and YouTube. And I look forward to talking to all of you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.